Well, it's 8:02 now. It's a decision that's seen the eyes of the nation focus on our state. Former President Donald Trump is now being barred from appearing on Maine's presidential primary ballot.
Secretary of State Shenna Bellows ruling Trump could no longer run for public office because of his role in the January 6th attack on the U.S. Capitol. Follows a similar ruling in Colorado earlier this month. And Secretary Bellows joins us live now. Good morning, Secretary Bellows. Thank you for joining us.
Good morning. Thank you for having me.
First of all, can you explain this ruling and why you think it's the right course of action?
Sure. And it's important for your viewers to understand how the process works in Maine because every state is different. So under Maine law, once I as Secretary qualify a candidate for the ballot, which I did with Mr. Trump, any registered Maine voter can bring a challenge under our election laws. And that's what 6 different people did. Marianne Royal, Paul Gordon, 5. Former State Senator Republican Kimberly Rosen, former State Senator Thomas Saviello, and former State Senator Ethan Strimling brought this challenge. And under the law, I was required to hold an administrative hearing. Now, that's not a public hearing. It is an adjudicatory proceeding where both sides can be represented by attorneys. They can present evidence, have witnesses, cross-examine those witnesses, rebut that evidence. And my role isn't as an advocate, but is to oversee that proceeding, hear all of the evidence, weigh carefully the facts, the record, the law, and the Constitution. And then Maine law requires me to issue a decision. Then any of the parties, and in this case, Mr. Trump, have 5 days to go to Superior Court. I stayed the effect of my decision, so nothing happens until the court makes a final ruling. If they can also have the right to appeal after Superior Court to the Maine Supreme Judicial Court and to the U.S. Supreme Court. So this is how the process works here in the state. I swore an oath to uphold the Constitution, and I fulfilled my duty. I reviewed the evidence, and in my view, the weight of the evidence made clear that January 6, 2021 was an insurrection and that Mr. Trump engaged in that insurrection in violation of Section 3 of the 14th Amendment to the Constitution.
Well, you're kind of standing alone right now. No other Secretary of State has denied a candidate ballot access under the Section 3 of the 14th Amendment. How difficult was this decision to make for you?
I'm mindful that no Secretary of State has ever denied or deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment. Now, keep in mind, Maine law is different than every other state. There have been other determinations I've made around ballot access. Just last week, for example, the Superior Court upheld my decision to prohibit Mr. Chris Christie from the Republican presidential primary ballot because he failed to qualify based on signatures. But I'm also mindful, and this is where this is so important, that no presidential candidate had ever before engaged in insurrection under Section 3 of the 14th Amendment.
Well, former President Trump's office says this decision is partisan and unconstitutional. What's your response to the suggestion this was made due to your political affiliation and that, according to Trump's office, it will disenfranchise voters?
My duty under the Constitution and Maine law is to review the facts and issue determination. And my political affiliation, my personal views of January 6, 2021 had no bearing on my decision. My decision was based on the facts, the law, and the Constitution presented to me in this hearing under Maine law.
Senator Susan Collins says that the ruling should be overturned. Also, Representative Jared Golden disagreeing, who, by the way, against a Democrat, with the decision, saying the former president should still be on the ballot and let the voters decide. What's your response to that?
So this is part of the process. The decision now goes to the Superior Court and, of course, can go on, as I explained, to the Maine Supreme Judicial Court, the U.S. Supreme Court. But I have a duty and an obligation as Secretary of State. That's what I reviewed, was my requirements of the job. And I could not decline to make a decision just because it's difficult or complex. These are the types of decisions I've had to make in the past. In 2022, I held a similar hearing in which I made a decision to bar a district attorney candidate from the ballot because he was not qualified, and that was upheld. So this is part of my job, and it's what I'm required to do.
And you've said the ruling won't be enforced until the courts weigh in. Can you kind of explain what happens next and the outcome you expect?
That's right. So At the conclusion of my decision, I noted that based on the compressed timeline, and it's a very fast timeline, the requirements of ballot preparation, and the novel constitutional questions in this case, I was suspending my decision, the effect of my decision, until the Superior Court has that opportunity to rule. Now, their deadline is January 17th, so we should have a ruling should Mr. Trump move forward with an appeal by then. And I will do what I'm required to do by the courts and by the law.
And again, the primary coming up in March. Secretary of State Shenna Bellows, thank you so much for joining us this morning.
Thank you very much.